Hi, I'm Searle, and I'll be doing aspects of the legal system and the lawmaking process. Bail. What is bail? Bail is the temporary release of an accused person awaiting trial. Sometimes on the condition of a sum of money is normally lodged to guarantee their appearance in court. Who can grant bail? The police may grant bail or refuse bail. If an accused person can object the refusal to grant bail, or if bail is granted, to the amount of money fixed for bail, or any conditions the police attach to the bail, for example, like the daily reportings at the police station, etc. Conditional and unconditional bail. A judge generally decides when to issue conditional bail as opposed to unconditional bail. Conditional bail means that besides for posting like monetary amount to ensure that the person is under arrest and appears in court the next day, there are also conditions attached to compliance with the conditional bail. The judge will also decide the conditions to require. Many times it's something to say like stay at home while out on bail, seek substance abuse treatment while on bail, seek anger management whilst on bail, stay away from people or something like that. That's it for that one. The rights for a defendant to legal representation on bail. The Bail Act 1976 says the perpetrator doesn't need to be approved bail if the court is content that there are substantial grounds for believing that the defendant, if released on bail, would mean that the court does not have enough evidence for allowing bail. That means they can buy themselves time to gather new evidence. Conditions should be implemented if they fail to surrender in custody, to commit numerous offences while on bail, or interfere with witnesses or otherwise obstruct the course of justice, whether in relation to himself or any other person. The rights to the defendant to legal representation on bail. Defendants might not need to be granted bail if the offence is triable way and it appears to the court that he was on bail in criminal proceedings on the date of the offence. The Criminal Justice Act of 2003 says that the Act amended some of the pace, particularly in relation to the stop and search powers and other powers. For example, for the trials without juries in complex fraud cases, new rules for the defendants, and the Criminal Justice Act 2003 in the Parliament of the United Kingdom also says that it is an extensive measure announced to renovate many areas of the criminal justice system in England and Wales. The right to the defendant to bail. After a suspect has been charged, the police must release him or her on bail unless there is doubt about the suspect's name or address. So like they've given the false identity. The police suspect that the person who is charged will interfere with witnesses or evidence. So like basically threaten people who's like witnessed the event happening. The suspect is thought to require custody over his or her own protection or the protection of someone else. And finally, if the police believe that the person will fail to attend court if released on bail. Access to legal representation. A duty solicitor. In several Commonwealth countries, including the United Kingdom, Australia, New Zealand and Canada, a duty solicitor is a solicitor whose services are available to a person either suspected of or charged with a criminal offence, free of charge. And if that person does not have access to a solicitor, well, that's all dependent if that person does not have access to a personal solicitor of their own. These solicitors generally are in private practice, in contact to the public defender system. In the United States, where the attorney employed directly by the state, which is our government, and will be assigned to handle the case from pre-trial to potentially appeal. Magistrates' courts. Summary trial process. If a guilty plea is entered to a summary offence, then it is normally very straightforward. the defence solicitor may put forward some form of order to reduce the severity of the punishment. So they might try and sit, like, if they've committed manslaughter or something like that, if there was a good enough excuse why, like mental health grounds, the punishment might be slightly less. Or when it comes to like fines. And to reduce the severity of punishments, the magistrates court will issue a sentence with the guidance of the clerk. If there is a non-guilty plea, there is generally a process which illustrated in the table below. And here it says the magistrates hear a summary of the facts, the defendant enters as a plea of not guilty, the prosecuting of their case goes forward, and it says that the magistrates give a verdict on the left-hand side here. You've got the defendant is found not guilty, may leave court, and then the magistrates deliver a sustainable sentence. If the defendant is found to be guilty, the magistrates seek guidance from the clerk on a suitable sentence. Magistrates court again. If a respondent in the magistrates court directs that they will employ guilt or instantly acts if this defendant has pleaded guilty, this means that the person loses the right to take the case to Crown Court. That will usually be tried by a jury as well as a judge. The magistrates court will then listen to some of the details in the case, and they can either refer the case to the Crown Court for a sentence, adjourn a pre-sentence report, sentence there and then. Presentations on the respondent's behalf can be made about penalising the light of the conditions of the case or any prior conviction. Nice little puppy there. Magistrates court. If a non-guilty plea or a plea has been specified, the magistrates court will go ahead and decide whether to deal with the case. Magistrates court will give us the respondent the choice of whether the case should be dealt with, either the Crown or the Magistrates court. The magistrates can be then chosen to be dealt with the Crown Court. Even if the defendant chooses to have the matter dealt with by the Magistrates court, the magistrates can still choose later to send the defendant to a Crown Court if they have insufficient sentencing powers for the case. So, like, if the crime is like a little bit more like serious, as in like a murder, or like when it comes down to like family grounds. Once again, the Magistrates Court, the sentencing powers. Magistrates Court can sentence a respondent to a summary or the tribunal, whether the offence is of a max of 6 months in prison or a £5,000 fine, and that's the max that the Magistrates Court can go. On the other hand, the magistrates are handed very clear guidelines on how to sentence. They are given by the Sentencing Guidelines Council, which is there, which tries to ensure that the sentencing remains consistent. Fines that can be imposed by the magistrates must not exceed certain maximum levels depending on the severity of the offence. The fines, there's level 1 fine, level 2, level 3, level 4, level 5. Level 1 goes to £200, level 2 is £500, level 3 is £1,000, level 4 is £2,500, and level 5 is £5,000, which is the max the fine can go for the magistrates. Go down to the Crown Court. The Crown Court sentencing powers are different from the powers of the magistrates. The Crown Court's able to sentence more serious offences, but again they must take into consideration the guidance from the Sentencing Guidelines Council. All offences have a maximum penalty, which is set out in the law, but some also have like a minimum sentence. For example, in the case of murder, a judge has no choice but to give a life sentence. There's a range of penalties available to judges in Crown Courts, including fines, community sentences, custody, and suspended sentence. And that was